Hi friends, good afternoon. For last few weeks, people are raising question if a show cause notice under 73 or 74 has been issued for multiple years. What is the legal position on this issue? Well, there are 2-3 questions raised. I'll answer 2 or 3. First question is, when you replied the show cause notice, you did not raise a question of jurisdiction, that the proper officer has no jurisdiction to issue a show cause notice for multiple years together. Second, the proper officer has passed order in original. Now you are in appeal. Now question is, can this ground be taken now? Answer is yes. It is a question of pure interpretation and law, and this goes to the root of jurisdiction. So once something that goes to the root of jurisdiction, it can be raised even before Supreme Court for the first time. And once you raise in appeal, there you have to make a prayer that the OIO is passed consequent to a show cause notice which is null and void, which is a nullity, as the proper officer had no jurisdiction to issue this show cause notice. Therefore, all consequential orders passed pursuant to a show cause notice of this nature must be annulled. So there is absolutely no issue. Be very clear. You can raise a ground of appeal, right? And then you can always say it was not raised earlier for a mistaken legal advice or for non-understanding, whatever ground you want to write. Even if you don't write, it's okay. Now, what happens to appellate authority? Appellate authority has a right to confirm the demand, annul the demand, or reduce the demand. He has no authority to remand. So once the order is without jurisdiction, he has to annul this order. Now he cannot remand. So if he gives any remand directions, you can question that by way of a review order or rectification. So he has to annul this order as this is without jurisdiction. Now what happens further when this OIO pursuant to a without jurisdiction show cause notice is annulled? Now there is an interpretation that under section 75 subsection 3 the proper officer may get 2 more years. That 2 years is a question of interpretation, whether he gets 2 years after his order is annulled or not. But my view is he may not get, but he can issue a fresh notice for each year separately if there is a limitation available. But if something had become time barred, that is supposing he issued notice for 5 years, let us say under 73, by the time this appellate order comes, 2 years order under section 73 have already become time barred. Then even 75(3) will not assist him. But this is a question of interpretation. Once order is annulled without direction, then it may not be amounting to a remand, but an order has been passed where original order has been annulled. So there can be a revenue view possible that this order has been remanded. Therefore, they have 2 years further from date of remand done by the appellate authority against OIO passed against a show cause notice which lacked jurisdiction. Therefore, friends, whenever you file appeal against such show cause notice and OIO, you have to raise a specific ground that a question of law is being raised for the first time, that show cause notice lacked jurisdiction insofar as it was passed for multiple years, which is not allowed. And therefore, the consequential order in original also has to be declared a nullity, and you cite whatever judgments you have. One more question has been raised that there is an SLP pending before Supreme Court on this issue which has not been disposed of on merits. For example, a Delhi High Court judgment said under for section 73 multiple years one show cause notice can be issued. Supreme Court did not bother about it. So Delhi High Court judgment remains binding. So if a Delhi authority does this, under section 74 and therefore 73 also, we will not be able to raise an issue on this because Delhi High Court judgment has become final. There is no contrary judgments of Supreme Court. But if other high courts have not gone to Supreme Court and their judgments have not been put to any challenge, those judgments remain. In Bombay High Court, I know there are 5 or 6 judgments on this issue, and the issue has been referred to a larger bench. Simply reference to a larger bench does not disturb the original judgment unless the larger bench passes the judgment. Therefore, in all those states where this issue has been settled against the revenue, we have a very strong point that the OIO passed pursuant to such a show cause notice has to be annulled. It's without jurisdiction. And if, say for example, Maharashtra, they say case has been referred to larger bench, well, the appellate authority or the proper officer cannot take this ground because larger bench has not yet delivered a judgment. Therefore, the jurisdictional high court judgment shall remain valid. Should you have any more question, drop a message. Thank you.